Closing arguments in the Holly Bobo case. We're back for a little bit more analysis. We're taking as many of your questions as we possibly can. Cathy Russon is still on the line with us, our senior trial producer here at LawNewz, and we're joined by a new guest. Yosha Gunasekera is here along with us for a little bit more analysis. Good to see you back.
Yes, thanks for having me.
Okay, so Cathy, we're at about the 8-hour mark here. The jury did have a question for the judge, but the response ultimately was that he couldn't answer it because it was a question of fact. In other words, that the jury needs to answer it, not the court.
Right. The information we got is it's a question about the evidence that he said he could not answer. So we don't really know what that's about. I did have a question in the chat room from one of the trial watchers that said, what's an example of something that would be that the judge couldn't answer if they had a question about, yeah, like you said, it's probably a question about fact, but do you want to talk about that just for a second?
Yeah, I mean, Yosha and I can bat that back around. So, if the jury asks a question of fact, well, the court can't answer it because it's a question that only the jury can decide. Did he kill her? Well, that would be an example of a question that couldn't be answered by the judge because it's a question of fact for the jury. If it's a question about the statute, can we convict on this and this, or do we need to find this in order to get to that? That's a question that the judge and the court could answer. A question for a readback of testimony, that's something that the court could approve and go ahead and do. Courts can answer questions about law. The jury is the one that's there to decide the facts. Maybe you can come up with a couple of other examples of that.
I'll just say that it says that the judge can't answer because it would be a comment on evidence. As much as we know.
Yeah, and that ultimately sounds like the old fact versus law dichotomy.
Yeah, I mean, it appears in this case there's actually a lot of facts that are in dispute, so of course a judge wouldn't be able to make that sort of judgment. Sometimes in cases where jurors can't remember things, a judge will allow part of the testimony to be read back. That's frequently common. I don't know if that's happening in this case, but ultimately a judge certainly can't state any facts, especially when so many in this case are in dispute.
Yeah, exactly. So, that's ultimately the dichotomy here. So, some questions the jury kind of prods at the court officials and says, well, we really don't know what we're supposed to do about this. Judge, what do you think? Do you think, do you think that it was Zach Adams, or do you think it was Autry, or do you think it was Shane Austin that took her away from her home? Well, that's a question of fact. The jury has to resolve that in some way if they deem it part of their deliberations. The court can't answer that. It's a fact.
Yeah, I wish that would have been done in open court. Many times we see jury questions come into open court because, at least for us who are just sitting here trying to analyze this case while we're waiting for a verdict, it could give us some insight to what's happening in that deliberation room.
Yeah, and right now we do not have that insight. So there's one question that we've had on the table here. We've had a couple of other ones here, Cathy, and maybe you and I can get into this a little bit more. We've got this alternate suspect that the defense has been kicking around here, Britt. Was he friends with the other conspirators here? Zach Adams, Autry, et cetera, et cetera. I'm unaware of any link between the so-called alternate suspect and then the conspirators that the courts are trying to deal with right now. Are you?
Well, what we know, and what is usually the answer to these types of questions, is it's a small town and everybody knows everybody. So my guess is they knew each other or of each other, but I haven't seen heard any testimony that they hung out, were friends, even that they did drugs together, because that seems to be a common theme with these defendants. But I haven't seen the connection of, and it's Terry Britt we're talking about. He's a convicted rapist. He's in prison right now for rape, and at the time he was like a really high suspect on the TBI's list for a while in this case, and he did testify. But I don't know if there's any connection.
That sounds like as good of an answer as any that I've heard, Cathy. Here's another one here. How much does Zach Adams and Holly Bobo's boyfriend look alike?
Okay, so Clint, her brother, when he first reported that she had been taken off in the woods with a guy in camouflage, had said, I assumed it was her boyfriend, Drew Scott, so I wasn't alarmed at first. And then when he talked to his mom, and his mom said, no, Drew is out hunting somewhere else, then he was alarmed. So the question is, did Zach Adams look like Drew? However, what came out in court and what the state is kind of what their theory was is they are now saying they think Shane Austin took her. They're saying the description that Clint Bobo gave of the man matches the build of Shane Austin, because there's a big difference in the build of Shane Austin than there is Zach Adams. Zach Adams is just, back then for sure, super tall, super lean. If you guys have seen his mugshot, he's just very, and Shane Austin was not. He was very big. He was like big and robust. And so, but I don't see the resemblance to Drew Scott, who we saw testify to Shane Austin. So I'm not seeing that. But what did come out in the trial is prosecutors think Shane Austin took her off into the woods.
Well, and that's an interesting theory because they're trying to get this defendant on the kidnapping charge. So,
right, but
what's the direct link?
Kidnapping by holding her in the trailer and not letting her go. So all of them could have kidnapping charges.
Yeah, I can see that, depending on how the statute's written in that state. I mean, I would think holding her in the trailer would be more like false imprisonment.
Well, that's true. But no, that's why they're all charged with kidnapping, though. See, nobody ever said a group of 3 or 4 people took her off into the woods. But Dylan and Jason and Zach are all charged with kidnapping.
Is this a situation where the state just can't get its theory straight?
Well, look, they don't know what happened, right? There's not a lot of evidence linking to this. It was a cold case. By the time finally something came out about it, they're having to work with from what everybody has said in this case, and then match up cell phone pings and all of that. So they're working with what they have. I don't think the state has any idea who took her into the woods out of that group. I just think they firmly believe this group is responsible for her rape and murder.
And we're back to this other question that we've been batting around for a while. Did the state investigate and completely rule out any connection between Clint Bobo and the Zach Adams meth crew? Again, this was something that was alleged on the stand by Jason Autry.
That he said Zach Adams told him that Zach had gone over to the Bobo's house that morning to teach Clint how to make meth. Now, as far as I know, there's no connection there at all. And I have not heard of Clint Bobo having a drug problem. So that simply came out from Jason Autry saying Zach had told him that. So the answer to the question is, to my knowledge, there's no connection to Clint and the meth buddies.
All right, Cathy, we're going to take another time out here and go back and listen to a little bit more of the closing arguments there from the defense attorney. We'll be back with more questions in a couple of minutes.
Church, he's dropped off there, and then that's ends of Jason's involvement. So that's the government story. Government then says several hours later, Jason shows back up at Zach's house, is looking for a pill. Jason, Shane, Zach, and Dylan go over to Dottie's to see Victor. Jason says to Zach, you don't have to kill her. Jason claims that Shane says to Zach, you didn't have to kill her. Zach says to Shane, you're just as guilty, you hit it. Zach punches Shane. This is all just part of the government's story. Again, none of this directly relates to evidence that shows that Zach Adams was involved in the kidnapping, rape, and murder of Holly Bobo. These are things that Jason's claiming is said later. 2 days later, Jason meets with Zach and Dylan at the gas station. Zach tells Jason he threw Holly's body near Kelly's Ridge. Zach tries to make a deal with Jason to have Dylan killed. Jason accepts the deal. Jason takes Dylan to the river, but this whole plan gets spoiled by a random boater. Sometime later, Jason says he sees buzzards at Kelly Ridge. He asks the homeowner to fish in their pond. And then while stealing deer equipment, Zach tells Jason, looks like we got by with this shit. And Zach tells Jason the real reason they were there was to show Clint how to make meth. Holly saw us, raised hell, and that's why we took her. So that's the government story. It's complete with its own little motive there, as the motive being to cook meth with Clint Bobo. The government also has Dr. Mark Ross that comes in. He says that the cause of death is a gunshot wound to the back of the head. The range of fire is indeterminate. The size of the hole is 9 millimeters by 11 millimeters. 32 caliber bullet is 32 inches in diameter, and anything that's 0.3, not 32 inches, 0.32 inches in diameter. Anything that's 0.36 inches or smaller could have made the hole. The government pulls in Victor Dinsmore, who comes in. He argues, he says that he hears Shane and Zach arguing, that they're going to, about who's going to hit it first. Victor trades morphine for Shane's gun at a later point. Victor gives the gun to his wife later. Victor tells his wife to get rid of the gun. The wife throws the gun in a creek. The gun is retrieved 6 years later. They have Steve Deaton come in. He's the water rescue man. He says that after 6 years, the gun is found laying under 15 inches of water, sitting on top of a drainage feature. And Mike Frizzell is the government's cell phone expert. He comes in and says that Holly's phone traveled north, and because of the locate and the call records, it puts Holly and Zach in the same general area. The end. That is the end of the government story. Well, now it's time to listen to the rest of the story, because when you dig down deep into what the government says and what the facts really are, you'll see that their story is absolutely full of holes. What they're wanting you to do is to ignore all the little all the many mysteries and the holes that they have left in their story, and to just completely then buy into their theory that what the government cannot explain, that's what Dylan and Shane did. That's going to be the theory of this case. So the rest of the story is, what we have is Candace Wood. She says that she sees a man staring at Holly and her at the coon hunt, and that he's standing there scooting dirt. So what she notices, and she says he really creeped her out, that it's a guy who's talking on the cell phone. She says he's standing there the whole time talking on the cell phone, scooting dirt with his foot, and he keeps looking at her and Holly. And what she also says is that he's standing still in one location, which is what you would expect if somebody's talking on the phone. She said part of what made her suspicious about him was that he just kept standing there and he didn't move anywhere and was watching them, and she said it was for 10 or 15 minutes. Well, that's what you would expect if somebody's on the phone, and I'm certain that there were two very attractive women there at the coon hunt. Maybe the guy was a creep, maybe he just happened to be on the phone and noticing two women, but she says that she felt threatened by it, and of course now, years later, knowing that Holly disappeared a few days later, she has feelings of what if she had told, but clearly at the time, what she saw did not upset her so much that she even would mention it to her boyfriend. At the time, she didn't even say, hey, boyfriend, Justin, do you see that guy over there staring at me? He's bothering me. So what she sees at the time isn't enough to really bother her. It's only when it comes up days later and Holly has disappeared that she starts to think about it and as she thinks about it and as she stews about it, it to her mind grows worse and worse, but all she describes is a person talking on the phone scooting dirt. The other thing is, so she draws this sketch of this person, and then she's shown a picture after she does the sketch of Shane Austin, and she says yes, and she identifies the person at that time as being Shane Austin. But she leaves out some very important features of Shane Austin at the time. The first feature is that Shane Austin has a very big, noticeable scar on his face. His mother even testified about it. He'd been in a motorcycle accident. He wasn't wearing a helmet. He hit a tree. He was life flighted to Vanderbilt. And he has a deep scar between his nose and his mouth, and it goes across his cheek. The other thing is Shane's whole right eye socket was decimated. It was flattened, and they had to have multiple surgeries where they were rebuilding his eye socket, and it left his eye droopy, which means the white of his eye, when you looked at him, the white of his eye was showing underneath the iris of his eye. That's something that's very unusual about people. And people would absolutely notice that. If you're looking at somebody, I can see even the people that have on glasses. I can still see the whites of their eyes, and I can see the iris of their eyes, even if you have on glasses.
Okay, folks, we're back with a little bit more analysis here, and we were sort of batting this thing around about kidnapping and false imprisonment because, Yosha, in a lot of states, those are very clear and distinct charges. So I thought maybe you could take us through that trajectory of law.
Yeah, so in most states, they're separately charged. Here in Tennessee, it appears to be that they've combined the two. So generally, the lesser included charge is false imprisonment. And all that means is you can be convicted of false imprisonment, but not convicted of kidnapping. Kidnapping adds an extra element on top of false imprisonment, and that extra element is basically the movement of someone. So for example, I could take someone and I could keep them in my basement and I could lock them there and I would be guilty of false imprisonment, but it's when I start to move the person, if I move them from my basement to another area, is when I could then also be convicted of kidnapping. But again, in Tennessee, they're all lumped together, which is an interesting quirk.
Yeah, so in some states, the laws are a little bit different than they are in others, and that might explain some of the debate we were getting into. I'm trying to give myself a crash course on Tennessee law as we go through this case. And a lot of times things that would result in cases being overturned or mistrials being declared in other states, in Tennessee, they just roll with it and say, well, the jury decided the way the jury decided. So that's been a surprise for me, at just how much deference they give to the jury process in Tennessee, because, oh yeah, it doesn't matter that the prosecutor threw in that evidence. The jury just looked and said, oh, there's enough there to convict anyway, so it doesn't matter. And it just surprises me because in states where I'm used to working, it's a much bigger issue.
And that's pretty disturbing that there's not more of an appellate practice. I think it's so easy to focus on the trial itself, but as an attorney, I'm always mindful that if I lose, that this case is going to get appealed, which is why I always want to make objections, and I want to make sure that they're reflected in the record, so then later another appellate attorney can then have a good appeals argument. And that's really foundational. Any good trial attorney is always thinking about the next step. And so if that's not going to happen in this case, especially when this man is facing the death penalty, it's especially disturbing.
Yeah, it's a surprise, but that's the way, at least it seems from my perception, that they're doing things in that state. Again, and maybe it's just the issues that I'm zoning in on, but so many of them that I look at and say, gee, that sounds like it would be a big deal. In other states, rarely get objections, and when I dig into it, every time I can find evidence that there was an objection about that issue, the appeals court just looks and says, it was harmless error or whatever, we don't care, is sort of what they say. So yeah, that's where things are. I mean, Cathy, the jury's been at it for about 8 hours here, a little bit more than maybe about 8.5 hours at this point. We heard from one of the local reporters that this jury was very skeptical on voir dire, and part of me wonders, just, is this jury really, really going through everything with a fine-tooth comb back there?
Look, I think they have to. Look what we're doing. I mean, there is a lot in this case. There's not a lot of hard evidence, and there's a lot of circumstantial evidence, and when you have that, they have to comb through it all, and they're probably going back through testimony, through their notes on testimony. We've talked about all the questionable characters that were on the stand during this trial, and they have to determine if they're credible, if they're not, if they take part of their testimony, all of their testimony, throw it all out. I would assume that, and there are multiple charges here and lesser included. So there's a lot to talk about, and I did not expect a quick verdict in this case.
Yeah, it looks like they might be going for a while here, and with a sequestered jury, of course, there's always the wonder, how long will they go? Are they going to want to try to get out of there by this weekend? Well, if they convict, there's a penalty phase, so they're still going to be there. I don't know if there's that sort of Friday afternoon, evening push that we see with a lot of juries in this case, because if they convict, again, they're going to be back there, dealing with a penalty phase. Probably
tomorrow. This judge holds court on Saturday because his jury is sequestered. We were in session last Saturday. So if they convict, What we have heard from the court is if there is a guilty verdict, they will go immediately into the penalty phase, unless it's too late in the court day to start, and then they'll start back up first thing. So I think if they convict today, we're going to be in court tomorrow.
Yeah, I mean, Yosha, I can't recall remembering a case where I've seen a sequestered jury over the weekend, other than the Stephen Avery case in Wisconsin more than 10 years ago. It's uncommon.
Yes, it's very rare to have a sequestered jury, especially even in the high-profile New York City murder cases that I've seen. There's never been a sequestered jury, so that's rare, but there is always a concern that they're going to try to rush through this, and that's particularly disturbing when someone's life is on the line here.
So, Cathy, I've sort of run through the list of questions that I've got. Have you seen anything else sort of across the so-called interwebs out there that we need to jump on?
That's why I apologize as people see me constantly looking away and not straight ahead, because I'm trying to keep an eye on the courtroom, make sure we have no information coming out of there. And I'm looking at comments. We talked a lot about the defense attorney, Jennifer Thompson, before we threw to that last clip. And I had a lot of comments on Twitter agreeing that she did not do a good job. And one of the questions came out of there is, what are the chances of an ineffective counsel appeal? What do you guys think about that?
Well, it's the most popular type of appeal there is. In fact, I think there's a statistic that says like 80 or 90% of appeals have that included in there. And I think failure to preserve a lot of the objections that she's done. I think there's a variety of missteps that she's taken. I definitely think an appellate attorney is going to have that marked highly on the list of potential appellate issues.
I'm trying to remember the standard review for that. So when you lodge a ineffective assistance of counsel claim, usually you have to show some pretty clear prejudice, if I'm remembering this properly. And if I've got it wrong, Yosha, yell at me and say, no, you idiot, that's not the way they look at these things. So they've got to show the prejudice beyond the actual conviction, and they basically have to relitigate their own case and say that a better attorney would have caught this issue, and not only would they have caught it, but they would have presented it in a different way, and the jury would have decided differently had they known it, if I'm remembering this the right way.
It's very, very hard to win the issue at appeal. There has been insane cases where they have found that attorneys have been drinking like during breaks of trials, just crazy things that attorneys have done, and they still have said, look, this attorney is effective. So the standard is impossibly high, and I don't think that even based on all the criticism of the defense attorney, that they're really going to be able to meet that burden.
You know, some things that have bothered me about this from the beginning, and I've sort of litigated them across the table here, Yosha, so you tell me what you think, but just the way questions are being asked in this case has resulted in everybody sitting here scratching their heads, sort of the way the defense attorney does, trying to make sense of what's going on. And, you know, prosecutors leading witnesses on direct, defense attorneys asking these sort of open-ended conversation-like questions on cross-examination. My guess is you don't practice in court that way.
No, open-ended questions are dangerous. You really want to control the witness on cross. That is extremely important. And one of the first rules I was taught when I started to do trials was always know the answer to your own question. And so you're going to ask the most pointed type of questions that you can. And there's a lot of information in this case. It's a lot of information for jurors to absorb. So as a defense attorney, you want to keep it as clean-cut as possible. And you want to continually reiterate your theme of the trial, not only of not guilt, but that the people have not met their burden in this case, and it's the highest burden in the criminal justice system, and I don't think that that has been done.
Yeah, now, Cathy, people are sitting there on social media, and you're noticing a lot of this saying, you know, hey, what's going on with this, what's going on with that, and I look back and say, well, the process is resulting in confusion.
No, for sure. I hate, look, we're reaching out to the defense attorney in this case, to Jennifer Thompson. We want her to come on. I hate to completely, constantly going at her, but it has made the people following this trial a little crazy in her delivery. Her delivery is her opening and closing super fast talking. Like, I don't even know how the court reporter was keeping up with her. It was really fast. And how is a jury going to follow that? And then she seems a little scattered, and she seems to what she did in her openings and her closings, especially her openings, is she wanted to just spit out every single thing she knew about the case to the jury. And that's how it came out. And it was fast, and it was all these facts or non-facts or whatever, and it went on and on and on and on. Not a lot of emotion at all. But just it was hard to follow her. And then I've said this before, that number of times she answered questions that it was very obvious she did not expect that answer to come out. And what we were just talking about is asking questions that you don't know the answer to. So it has been very frustrating to watch what's going on in that courtroom on that side of the room.
Yeah, and I think the prosecutor has walked all over it as a result. You know, the prosecutor took a lot of liberty. Yosha, this whole closing argument from the prosecutor was basically talking about Holly Bobo's last day on Earth, and this is what she had, and this is money that she was supposed to spend, and this is where she was expected. And the prosecutor was almost in tears on the rebuttal. And I looked at that and said, well, this is a risk, because the judge has got an instruction in here saying you're not supposed to decide based on sympathy for the victim, but the prosecution's rebuttal was pretty much all about sympathy for the victim.
And that's deeply concerning. I mean, the defense then has to object and then has to do a sidebar with the judge to say this is completely inappropriate. Some attorneys don't want to object during opening and closings of the prosecution, and I can't understand for the life of me why. I mean, I have objected before and asked for a mistrial in an opening when the prosecution has shifted the burden. It is important at every moment of this case for a defense attorney to be vigilant. And one thing that made me shudder in the defense attorney's closing was that she was saying that her client was 100% innocent. And I think, you know, that's the end goal, right? She's trying to get an acquittal. She's trying to win. But those little things, those phrasings of innocent versus not guilty, I think they make a big difference in a jury's mind. And it sounds like it's just semantics or we're mincing words, but all of those little things are creating a picture. I think a jury, even though they're the same thing, essentially, a jury finding someone not guilty and then a jury finding someone 100% innocent without any blood on their hands, it's a different thing. It's more that they just haven't met their burden. Maybe he did it. I like to say probably you think my client did it, but probably is not enough. And I think that would have been a more effective closing for her.
Yeah, I agree. I mean, there's this one other thing that the prosecutor said, and you know, I'll leave this on the table as kind of the last question here. The prosecutor said on rebuttal something along these lines, and it might not be an exact quote, but I'm close here. If you believe the defense theory, then ladies and gentlemen, let him go. Well, my reaction to that was this sounds like burden shifting. Now, it might not be a textbook definition case of it, but I was ready. If I were sitting there, I would have objected to that. Your Honor, this sounds like burden shifting.
It's completely burden shifting. It's completely inappropriate. The defense does not have to have any kind of theory. And that's a popular thing that defense attorneys like to voir dire on. I can sit here and I can say nothing. My client can say nothing. We do not have to present a case because it's all on the prosecution. The prosecution has to do heavy lifting. So that's objectionable, and I have had and seen attorneys ask for mistrials on less, and granted that may not be mistrial worthy, but it is definitely an issue to be preserved for appeal.
Yeah, and it wasn't. But we've got to let you go, Cathy, as I understand it. So good to see you again. I'll talk to you later today, I'm sure, but the audience probably won't. So Cathy Russon, trial producer here on Law News. Good to have you on again for a good debate.